Good evening. My name is Carl Tanksley. I'm the Director of Legal and Labor Relations, and I want to welcome you here to our Governance 4 presentation this evening. Governance 4 is part of the mandatory training program, and glad that you were able to show up tonight and participate. It's going to be an interesting presentation. We're going to cover some cases and some updates for you. If you have any questions or issues, you can just go ahead and ask a question. We'd be more than glad to take the time to answer it. But because it is a longer type of presentation, I'm going to go ahead and jump right into it. So to start with, the first case I'm going to talk about tonight is Barilla versus Cliffside Park Board of Education. This is a case that has raised a bit of controversy in the state recently because our appellate division decided that when the board negotiates a contract with a union, that the board really has to be attuned to what those provisions are, even if the union should agree to the terms that are being negotiated. Now, in Barilla, we have a situation where the predecessor contract had a clause in it that provided for a payout of accrued and unused sick leave for certain individuals, certain employees who had enough years in the district. When they retired, they received a $25,000 payout, up to $25,000, for their accrued and unused sick leave. In the successor contract, both the board and the union negotiated that provision down from $25,000 down to $15,000. And even though it only affected a handful of individuals in the district, 4 or 5 or so, those individuals were not happy because obviously if you're retiring expecting $25,000 and then only receive $15,000, you're going to be a little bit upset about that. And that's what happened here. So these individuals who were affected by the change in that clause decided to file a petition, and it came before the appellate division. And the appellate division said essentially that the board, and the appellate division blamed the board completely, the board could not negotiate the way it did to take away those benefits, those accrued and unused sick leave benefits. The appellate division said that once a benefit is vested in a person, once it vests because of the sufficient time they've put into the district, that can't be negotiated away. The board can't divest them of that benefit. So as I said, this matter is going before the Supreme Court. The Supreme Court has granted certification, and later on this year, hopefully late spring sometime, we'll hear an answer from the court because school boards did participate as amicus in this matter. One of our arguments was one that we hope the court will take up, and it's the fact that it's called collective negotiations, right? The union as an entity bargains on behalf of all of their members. And if the union agreed to those provisions, to those clauses, then everyone in the union has to abide by that. They voted up or down, and the majority of the members voted it up. So if the court, or what the appellate division has done, is basically allowed individual members to negotiate on their own behalf without the union. And if this goes forward, what's to stop other individuals from doing the same thing in other districts? So instead of having collective negotiations, you have to negotiate with the union and negotiate with any individual who doesn't agree with what the union has done on their behalf.
Was this contract already ratified when they filed?
It was. It was ratified. The people who were affected voted against the contract, but the majority of members voted for it. So the contract went through, and that's when the petition was filed. So hopefully the Supreme Court will rule in the school board's favor, but stay tuned. We will have to see. Second case is Under the Sun versus Evesham, involving a daycare, a preschool, where the board was actually operating the preschool, and the board had a little practice or policy of allowing students who were underage or non-residents to participate in the preschool program. Because that violated the regulations, the school district was ordered to shut that daycare down and cease operations. So, not that happens in a lot of districts, but on occasion, we do see violations of regulations happen from time to time. Next case works out a little bit better for school boards, and it involves LM, or it is LM versus Alamucci Board of Education. And a colleague and I have this conversation all the time about homework. My colleague at school boards doesn't believe in summer assignments. He feels as though that when the kids are on summer break or Christmas break, that they shouldn't have to read a book or do any homework because it's summer break. I take the opposite approach. I think that students should do a little bit of something at least over the summer hours. But in LM versus Alamucci, we have a mother who felt the same way as my colleague did. They said it's summertime, students shouldn't have to read books or do math or do anything because that's their time. And when she received notice that there was going to be a summer assignment for her two students, one fourth grade and one rising fourth grade, one rising seventh grade, she emailed a teacher and said, look, my kids are not going to be participating in the summer reading program because I object to it. I'm not consenting to that type of program. So the summer went on, the students were assigned work to do, and the students didn't do the work. And the seventh grader in particular came back to school, told the teacher that didn't do the assignment. His mom said didn't have to. Plus, he was on vacation. So teacher said, okay, fine, thank you, marked zeros. And at the end of the marking period, although the student didn't fail, his grade was reduced because of two missed assignments. So a parent was upset. Parent filed an objection and filed an appeal before the board, first to the superintendent, then to the Board of Education. The board said, look, it's a summer reading policy. It's been that way forever. We're not going to reverse our policy just because you feel as though the students shouldn't have to work over the summertime. Parents said, yes, but actually it's not your policy. There's nothing in policy that allows the teacher to assign homework over summer break or over a holiday break. So because it's not supported by policy, it's an illegal practice, and I'd like to have those grades removed, those zeros removed from my son's report card, my student's report card and grades. Board said thank you, but no, we're leaving things the same. So the parent then appealed to the commissioner, arguing that the board's practice of assigning homework during summer and extended hours, vacation hours, violated her First Amendment right to privacy because it was interfering with her ability to raise her children the way she thought was fit. Because the students had to spend time doing reading for school, which they weren't in, and honing up their skills for a period, and it deprived them or interfered with their ability to go on vacation and have other family events. And again, there's no policy supporting this. So the commissioner said, I understand there's no policy supporting this, but it's good pedagogical practice. We've seen studies for years and years of how students lose skills over the summertime, and they need to have some type of reinforcement to mitigate the loss of those skills. And as to the absence of policy, well, as a parent, you have to prove that the board's action is arbitrary, capricious, or unreasonable. And here, it's perfectly reasonable to assign summer homework because of all the studies that have shown it. So even absent a policy, the commissioner said boards can sustain the practice of summer homework because it's good pedagogical practice and it helps maintain those skills. But for you as a board member, what I would say is just to remove this irritation, just to give parents, avoid that type of argument, you might want to take a look at your homework policy and make sure that it allows teachers the discretion to assign homework over Christmas break or over summer break. That way you can take away that argument that the parent had. Next case, Rosenblit versus Lyles is also an interesting case because in this matter, the school district had a policy, or I guess a practice, of negotiating with the union, and as part of that practice, there was a clause that actually provided for the union president and vice president to be paid their full salaries, even though they weren't providing any services to the district as teachers. The union president and vice president spent all of their time handling union matters, handling complaints or issues pursuant to the contract, and provided no services at all to the district. These taxpayers argued that that was a gift of public funds, that essentially the board was paying the union money that, and it wasn't receiving anything in return for those monies. And that's actually a constitutional violation. So in Rosenblit versus Lyles, the court actually overturned the contract and said that that was illegal to pay union officials public funds to perform union duties, essentially private duties, and not receive anything in return. Now, one of the arguments in Rosenblit was, well, teachers are paid all the time when they don't provide services. You have sick leave, and they're not providing services to the district during their sick leave. They have sabbaticals, they're not providing services then. But the court addressed those and said with sick leave, obviously there's a statute that allows for teachers to be paid when they're not working and when they're sick, and we don't want to throw teachers out of the job just because they get sick. That's, you lose all that time and experience, and that's not a wise public policy. But with sabbaticals, the court said that the district does get something in return. The teacher goes away, they're allowed to spend an extended time getting themselves refreshed, and they're able to return back to the classroom with new inspiration and most often new knowledge, because they do learn things when they're on sabbatical. So there's a benefit there. That doesn't happen when you have a teacher assigned union duties all the time, full time. Now the court left open the question of what happens when those teachers aren't assigned union duties full time, they're only assigned union duties part time. So we'll have to wait for hopefully the Supreme Court to address that, or maybe in a later decision. But for right now, full time, we know you can't do it. Part time is unclear.